Good afternoon, everybody. It is July 26th, and it is good to be back with you. Here in New York City, it is finally a little cooler. It has been sweltering, and of course, the whole country has been dealing with some very serious heat over these last few days. And we have, though, plenty to talk about in terms of the content ahead today. I'm delighted to be joined by several of my colleagues. And if Kathy, you'd advance to the next slide, I'll walk everyone through the agenda. So thank you, Kathy. First, we'll have a few comments from me, and then I will turn it over to Barbara Lee, who is presenting for the first time here on Business in 22, and we'll be covering some breaking news concerning cannabis on campus. Really looking forward to hearing more about that. Teresa Rusnick is back, and a number of you, when I was hosting 2 weeks ago, had questions about the sexual harassment hotline that New York State was getting ready to stand up. It is now out, and we'll learn all about it. Seth Gilbertson is back once more, at this time to talk with us about a new Bundy 8 requirement, and it'll be my role to give you some coverage of a new regulation that's proposed concerning the Office of the New York State Medicaid Inspector General. And then we'll leave a minute or two as time allows for your questions. So if you'd go to the next slide, please, Kathy, I will walk everyone through what things look like on the COVID front. Unfortunately, I have to share what is, I think, evident to all of you who have tuned in regularly. We are not seeing much improvement in terms of the prevalence of COVID. Indeed, we are still seeing significant upticks in each period. The last 2-week interval, when I presented to now, has resulted in a 14-day change of 19% nationally. It is not, of course, in terms of the volume of cases like what we saw during the first Omicron waves, but it is certainly significant, and it is not really something that we're seeing over the course of the summer quelling in any meaningful respect. So if you go to the next slide, Kathy, I will just try to depict that a little bit more plainly for all of you. If you look on the left side, you'll see that as of July 12th, we were starting to see number of areas around the country getting darker, which indicates more concentration. Really, but for the Northeast now on July 26th, there's a lot of darkness and concentration around the country. Here in the Northeast, certainly COVID is circulating. As you know, I am recovering from it, or I have recovered, thank goodness, from it. And it is going around here. And the good news is that for most, knock on wood, it is certainly an inconvenience, yes, but we are learning to manage and live with COVID, which is something certainly we at Bond are all grateful for. But as it relates to the regulatory structure, I'll tell you in a moment a little bit more about what is changing, and the short answer is that very little looks different. We're really moving into the phase of living with the virus. And so if you go to the next slide, Kathy, let me show you a little bit what that looks like. We're still seeing in New York State a continuing uptick, 21% actually, again, since the last 2-week interval when I was with you. But again, if you compare that with the national trends, all of this, of course, limited by where we get our data from. With all the home testing, there's a lot we don't know. We are definitely seeing concentrations around the country that are greater than what we have in New York. Next slide, please. So if you look at the 2-week differentials, again, about 21%, both in the 2 weeks preceding this and then in the 2 weeks prior to that. So across the state, the areas of the concentration are generally the same. New York City up there, and then some other counties depicted below. But if you go to the next slide, Kathy, before I move into monkeypox, which is, of course, another significant issue we should be talking about, I just wanted to track back to that comment you made. What we're really seeing is just continuing focus on trying to get back to whatever quote unquote normal is. And I know that many of you in the businesses you lead and otherwise are involved in operating are doing just that. And we at Bond are here to provide you with updates as we receive them around the various regulatory and otherwise the statutory changes that are relevant. But as far as the pandemic is concerned, there's nothing too significant today to report in those domains. It is worth noting that the public health emergency was renewed again. That was earlier this month since I last was with you. We are going to get warning from the federal government if the PHE is to be wound down. That was a promise we received from the Secretary of Health and Human Services with about 60 days of advance. We did not get that this time, and again, it's extended. But let me move now to monkeypox, and it's another issue that we'll be needing to track from a public health perspective. Exactly how it's playing out is still unfurling, but what we do know is that the World Health Organization just a few days ago took, as the Times reports here, the extraordinary step of declaring a global health emergency again. And essentially, it's a public health emergency of international concern, which only applies to COVID as well as to polio. So this is a big deal. And as all of you have likely been tracking, the vaccination rollout has been a place where a lot of attention has been focused in terms of building up the stature and the capacity around the country, let alone around the globe, in places where we are seeing upticks. And there is more of this story to tell, and we will be watching it closely and certainly reporting back as it affects all of your organizations. And so with that, let me make sure that I provide you with some background on Barbara, who is with us, as I noted, for the first time, but who has an extraordinary career that precedes her arrival to Bond. Among other highlights that I would want to just raise, she has co-authored and has been regularly updating the treatise, The Law of Higher Education, which is considered one of the most recognized treatises on higher ed law around the country. And she has written prolifically, including a legal guide for student affairs professionals and also academics in court, The Consequences of Faculty Discrimination Litigation. There's much more about Barbara that you can learn, but suffice it to say, she is one of the individuals who comprise our really nationally renowned higher education practice. And she's here to tell us about that breaking news I described around cannabis. It's an area where, of course, there's so much developing and so much that we are learning here together. And Barbara, with that, I'd love to allow you to get into the contours of what's changing and what our viewers should know. Barbara, the floor is yours.
Okay, thank you so much, Gabe. And hello, everybody. It's nice to be with you today. I'm going to be talking about some recent developments and some not so recent developments, actually, in the interplay between cannabis and federal and state regulation of marijuana. My remarks will be primarily involving colleges and universities, but the cannabis industry also is probably going to find them interesting, let's hope. Gabe mentioned a surprise. We got an interesting piece of information last week that the governor of New York has created a program for community colleges to help students prepare for jobs in the cannabis industry, which is a wonderful, wonderful idea. It's workforce development. One source estimates, for example, that global cannabis sales will reach 33.6 billion, that's with a B, billion, by 2025. Which is a powerful incentive for entry into this growing industry, obviously. Cannabis, marijuana, I will use those two words interchangeably, has been legalized in the last 2 decades in more than half of the states. 39 states allow the use of medical marijuana, while 18 states and the District of Columbia permit both medical and recreational marijuana. Next slide, please, Kathy. Despite what would appear to be lawful access to cannabis, it's still classified by the federal government as a controlled substance, and which means that its possession, sale, or use is prohibited by federal law, even in those states whose laws have decriminalized the use of cannabis. And this is the crux of the problem that we're going to be talking about today. But colleges and universities are subject to stricter federal regulations than other organizations through a law that prohibits possession, use, or even presence on campus of a Schedule I drug, and marijuana is considered to be a Schedule I drug. And if the institution permits the possession, use, or presence of marijuana on campus, they could lose all their federal funding, including federal student aid funds, which obviously is a huge problem for colleges and universities. And while the U.S. Department of Justice has, for the time being, agreed not to enforce the federal criminal law regarding marijuana in those states that have legalized it, that could change at any moment. But the U.S. Department of Education has not, I repeat, not made such an agreement with respect to enforcing the Drug-Free Schools and Communities Act. So having marijuana on campus remains very, very risky under federal law because of the U.S. Department's mandate to enforce the law. Next slide, please. Let's look at the issues related to conducting research on marijuana on campus. The Drug Enforcement Administration, or DEA, is a unit of the U.S. Department of Justice, and the DEA determines the extent to which marijuana may be used in research, either on campus or even in a private business like a pharmaceutical company. The DEA controls who may grow marijuana, requires licensed growers to sell their product to the DEA, and requires organizations that wish to use marijuana for research to purchase the marijuana from the DEA. For years, the only licensed grower in the United States was the University of Mississippi, and their marijuana was very tightly controlled. The DEA is now accepting applications from other potential growers, but so far there's no indication that the DEA will let those growers sell directly to researchers. These requirements apply in all US states, even those that have legalized the possession and sale of marijuana. Next slide, please. In addition to regulation by the DEA, the Food and Drug Administration, the FDA, considers cannabis containing more than 0.3% tetrahydrocannabinol, I think I said that right, or more familiarly, THC, to be a regulated drug, and thus requires an individual or an organization that wishes to conduct research on marijuana or to submit a new drug application, just like a pharmaceutical company or other medical researcher would need to do. In order to get permission to use marijuana in scientific research of any kind, the researcher must send an investigational new drug, IND, proposal to the FDA's Center for Drug Evaluation and Research. And that also has an acronym that I won't bore you with, just as any other potential drug research would require. Another concern for colleges and universities is the potential for conflict of interest or conflict of commitment for faculty if faculty researchers or any employees actually of a college or university work independently with private companies on research related to marijuana on their own time. Next slide, please. Let's look at curriculum issues. There are also concerns about developing certificate or degree programs that are focused on the marijuana industry. Some colleges and universities offer degree or certificate programs in cannabis studies, such as the science of cannabis, biology or chemistry of cannabis, or the business of cannabis. Even in states that have decriminalized the possession of cannabis, as I mentioned, federal law prohibits the on-campus use of cannabis with greater than 0.3% THC without a federal license. That means that faculty and students will not be able to work with marijuana, either in the lab or in other aspects of the curriculum. Now, hemp, which is in the family of marijuana and has less than 0.3% of THC, is excluded from the federal law forbidding Schedule I drugs, and therefore may be used on campus for research. But the chemistry and biology of hemp is different from the chemistry and biology of marijuana, although they are related and both contain THC. Next slide, please. So there are a number of questions that university council and academic administrators need to ask before either a research program or an academic program leading to a certificate or a degree is initiated. First, is the program using a Schedule I drug in research, like marijuana? And if so, does the institution have a federal license to conduct research on cannabis? And has the marketing information for certificates or degrees explained that students will not be working with marijuana, but with hemp or with some other substance that does not contain more than 0.3% THC? So by now it must be obvious that engaging in cannabis-related research, whether on or off campus, or offering courses related to marijuana, is difficult, complicated, and risky. For a college or university, the penalties for violating federal laws, especially those directly related to the receipt of federal funds, are very serious and could have very serious budgetary consequences, as well as public relations repercussions. Given the current size of the cannabis industry and its projected growth, which is substantial, members of the cannabis industry may be eager to engage institutional researchers and students in studies of its effectiveness and safety. And they are clearly relying on colleges and universities to provide a trained workforce for their industry. These pressures may be difficult to resist. Nevertheless, until and unless federal law changes, especially those directly aimed at higher education, council should be very wary of allowing cannabis research or academic programs that rely on cannabis on campus. As you heard at the beginning of my presentation, the Governor of New York has announced a program to support the development of certificate courses to train researchers for the marijuana industry. We're waiting for the folks in Albany to clarify the program's intentions with respect to the conflicts between federal and state law, which are still very real. As soon as we have more information, we will send it to you, or maybe I'll pop up again in another webinar and let you know the information that we've gained. So stay tuned, there's more to come.
Barbara, that was really informative. Thank you for taking the time. It is exciting to really learn about the developing law and its implications in settings such as the classroom environment, for instance. And we will take you up on that offer to come on back when there is additional information for all of us to learn. But as background, Teresa is here from our Rochester office, and as you are all familiar, she is a regular presenter on Business in 22, comes to us with a highly esteemed background in labor and employment, many recognitions regionally in terms of the quality of her work. And we look forward to learning, Teresa, from you as well. The floor is yours, and please do go right ahead.
All right, thanks, Gabe, and hi, everyone. I'm happy to talk about not just the sexual harassment hotline, but another hotline that New York also put out on the same day on wage theft. So I'm going to do both of those quickly in 10 minutes and hope to get you the most material possible. Kathy, if I could have the next slide. So we'll start with the sexual harassment hotline. So on July 19th, the governor's office announced that it had launched the sexual harassment hotline for employees. This is part of legislation that was passed earlier in the year, I believe back in March. This legislation was announced, and then the state had X number of days to actually get us the hotline information. So that has happened. The hotline will be operative from 9 to 5 on all work days, excluding holidays. It is run by the New York State Division of Human Rights, which is our state agency that enforces workplace protections for employees of New York State. So it prevents discrimination against employees on the basis of race, age, gender, and all of the rest of the New York State protected categories. The Division of Human Rights, along with the whole of New York State, has had a renewed focus on sexual harassment in the past couple of years, so it makes sense that this hotline would be housed there. The hotline is staffed by pro bono attorneys, or attorneys who are not being paid for their services. The Division of Human Rights was supposed to work with the Bar Association and other like-minded groups to get the hotline staffed, which they must have been able to do since it is now officially operative. The attorneys are supposed to provide advice on legal rights, as well as individual facts and circumstances. And I have included the hotline number there for you. It's also 1-800-HARASS-3. if you're looking to see it that way. And probably the most common questions Gabe's already alluded to. What are we going to have to do about our policies and training? Do we have to include this phone number? What exactly do we have to say? Some of that's a little up in the air still. The original law, as it was passed, and I'm talking about the law announcing the hotline, definitely said employers need to include this information in their materials. It's a little ambiguous as to whether they have an obligation to do that as soon as the hotline is announced, which would be now, or as soon as the division updates its materials, which has not yet happened. I think we can all read the tea leaves on this one. You're going to need to update those materials, whether now or in a couple of weeks or a couple of days. So make sure you have that in your policies. Of course, we're always happy to help and include that in your annual training as well. Okay. Next slide, Kathy. Okay, then we had a second hotline announced on July 19th. It was a big day for hotlines. And this one was the wage theft reporting hotline. So this is run by the Department of Labor, so a little bit different than the Division of Human Rights, but that makes sense because the Department of Labor investigates wage and hour violations on behalf of New York State employees. And it's part of a larger wage theft task force. Along with the announcement on the hotline, there was a lengthy announcement by the governor announcing a future online reporting system and other methods by which New York State is trying to attack and stop wage theft, including a long list of businesses that they have recently, prosecuted or received money from to pay back their employees for wage theft. So it's an interesting announcement. I encourage you to check it out. I'll put the link for that in the chat. But for our purposes, they have established a hotline. I'm not sure how often this one is staffed. The announcement wasn't clear, but I would assume Monday through Friday, normal business operating hours or whatever the hours are for the Department of Labor. Online reporting will follow. The interesting thing about the online reporting is it's supposed to be available in several languages. So we'll see what DOL does with that. I think for employers, the main takeaway from this announcement is that the Department of Labor has renewed its focus on wage theft. Employers need to be aware of how they're paying employees and make sure they're not falling into any of the more common pitfalls of wage theft. And I've listed some of them there, which include things like misclassifying your employees. So if you have an exempt employee who's supposed to be non-exempt and is therefore not receiving overtime, that can be a common area of wage theft. Meal periods that aren't being paid appropriately, paid for manual workers, which for everyone but nonprofits needs to be weekly, and then all other types of wage and hour violations, of which there are many under New York law. So, always a good idea to make sure you know why you're paying what you're paying. And this is just a good reminder that the Department of Labor has a renewed and emphatic focus on this area of the law. Okay, Gabe, I think that's my announcements on the hotlines.
Wonderful. Well, thank you for getting us up to date and doing so well under 10 minutes. You have a few questions that have come in through the chat. I think you alluded to the answer on one. The question is essentially whether these hotlines will be functioning on a 24/7 basis. As I heard you respond, essentially, they're getting staffed up and they're building capacity, and in neither instance is there that expectation just yet. Is that fairly stated?
Yeah, right now it's Monday through Friday, 9 to 5, excluding holidays. So okay. That's at least for the sexual harassment hotline. That for Department of Labor, they haven't explicitly said when and how it's being staffed.
Okay, and so I'm confident to those of you who have posed questions in the chat, Teresa will answer as many of them as she can in real time, and otherwise we will come back to you with fuller answers. But based on the volume of questions that we're seeing in the chat, this was very appreciated information. So thank you, Teresa, for bringing it forward here. And with that, I'm going to turn to Seth, who is back with us for actually, what was another round of this Business in 22 webinar this month already, where in the end of July. And so right now, what Seth is here to tell us about out of the Buffalo office is the new Bundy aid requirements, which are essentially ones that are pretty hot off the presses as well, much like Barbara was describing in terms of some of the cutting edge material we're learning about in the higher ed environment. And Seth, as you know, has deep experience working in our New York State University and broader scholastic systems. So has a lot of experience on the other side of this as well. And so looking forward to hearing, Seth, what you've learned and what you can teach us about the new diversity data and the improvement plan. So the floor is yours. Thank you.
Thank you, Gabe. I'm always happy and honored to share a platform like this, especially with first ballot Hall of Famers like Barbara Lee. This is a bit of a recap of a pop-up presentation that I did last Thursday. So it's going to be sort of an abbreviated version. Hopefully you'll stick with us even if you did attend that webinar last week. Next slide, please. So there are, in the most recent budget bill, there have been some restrictions, I'll say, added to what is still in the budget bill termed unrestricted aid to independent colleges and universities, informally often referred to as Bundy aid, which most private colleges and universities in the state receive. So this has been in the works for a little while, since at least February. It has been in the budget bill that was passed, but the guidance from the New York State Department of Education just came out, I think last week actually, putting some sort of meat on the bones of these new requirements. And there are two requirements, and they're coming up very soon. September 20th, 2022 is when the first submissions are due. And if these submissions are not received by that date, we are told that the institution will be ineligible for a Bundy aid disbursement this year, which is a pretty big deal for many private colleges and universities. And it may not be a lot of money, not as much money as it used to be, but it's something that most colleges and universities rely upon. So it's certainly something we want to take very seriously. And fortunately, we have, until September 20th, and there's not a lot going on in higher education in the academic calendar between now and September 20th, as we all know. Two requirements here. Data that we need to submit, which is sort of the easier of the two requirements. This data is often already going to exist. I'll show you exactly what the data that is going to be collected is, but it's data that you probably already have somewhere for OFCCP requirements or something like that, and basically need to collect it and submit it in the form developed by SED. And then the second requirement is a development of 3 goals, customized goals by the institution to improve faculty diversity at the institution, along with measurable metrics that you can provide to SED to show whether or not you are meeting those goals. We are told in 2024 and again in 2026, we're going to be submitting progress reports of some sort as to how we've done in meeting the goals that we are now setting. So there is a definite schedule, although the way that the exact date and the way that progress is going to be submitted is a bit unclear at this point. Next slide, please. So the diversity that the goals are meant to improve is extremely broadly defined. It includes things like religion, socioeconomic status, veteran status, and even language. And I just want to point to that because when you see the narrow definition in a moment here, next slide, you'll see this is actually what SED is asking colleges and universities to submit. It's a much narrower version of the broad definition of diversity that we see. They're basically just asking for gender, race, and ethnicity, as opposed to all those other categories of potential diversity that we can actually look to when we're submitting goals. So the data and the goals are not necessarily joined at the hip, I guess is one way to put that. We're going to have to submit the data, we're going to have to submit the goals, but they don't necessarily have to correlate directly to one another. I think for the most part, we're going to be looking for correlation, for opportunities for correlation, let me say, but they don't necessarily have to, certainly not all three of the goals. Next slide, please. So what are the goals? Three measurable goals. They need to be measurable goals because we specifically need to provide measurable metrics that that SED can use to assess whether or not the goals have been met. So they can address, as I say, the data that's submitted separately that includes gender, race, and ethnicity, or one of the other sort of, I'll say, broader categories related to diversity. But they do need to include those metrics, include those some form of data that can be used to measure progress towards the goals. And there are going to be 2 and 4 year intervals that we're going to be looking at as we develop these plans and goals. Again, 2024 and 2026. Next slide, please. And here is the actual sort of tabulation that SED is looking for. Again, 3 measurable goals and the data information relating to that goal. They say that if the data that you're using to inform or measure the goal relates to the other data that we are already submitting, the other diversity data in the table that I already showed you, then you could just say that. If it's going to be a broader type of diversity that you are aiming to improve, then you need to include that, what information, what data is going to be used, what metrics are going to be used to measure that goal for each of the goals that you submit on September 20th. Next slide, please. So when we're developing these goals, Bond has developed several strategies and approaches to setting up these goals. But here are a few sort of baseline pointers that you can, as you're thinking about these, that you can keep in mind. What are you doing already? There is nothing that requires these goals to be anything new. We're required to submit them now, but if you have existing programs, plans, goals that you can use, that you can repeat basically to meet these requirements, there's no problem with you doing so. There's nothing that requires you to come up with something brand new here. So if you have something, make use of it now. What are the existing data and demographic trends at your institution within your faculty already? We want to sort of swim with the current here and not against it. And if you have trends and demographic data that shows that your faculty is already diversifying in a particular direction, go with it. Support that. Use that as a way to sort of meeting goals as approachable as possible. What are the strengths and experience that you can leverage at your institution? Are there existing programs or grants, resources, human capital that you can use to leverage to help you meet your goals? If those exist, you want to incorporate those into your plans and into your goals now, so that frankly, it's easier to meet your goals. And then finally, create goals that you control. I can't emphasize this enough. We don't want to be relying on luck, on the alignment of the stars, to be able to meet our goals that we're setting for ourselves now. Now is the chance to set goals that you know you can meet. So focus on setting goals, creating goals that you control the outcome to with your plan. Next slide, please. So you do need to have a plan. It's not actually required to be something that you submit, but it makes sense that if you have goals that you're gonna have to be submitting, you have metrics that you're gonna be submitting, you have data you're gonna be submitting, you need a plan in order to meet those goals. Have a responsible individual, I would highly suggest is important to have somebody who everybody can look to as that's the person who's responsible for meeting this particular goal. Be flexible, be adaptable. 2 to 4 years can be a long time, a lot can change. So think about that as you're developing your plan and incorporate some flexibility into it. so that you can meet your goals through multiple approaches if different avenues open up or close down, as the case may be. We're not required to submit those plans now, but I would suggest you create them with the assumption that they are eventually going to receive a wider audience. SED could change its mind and ask for those. Faculty and students and media could request them, and we may feel obliged as a matter of institutional transparency to divulge them. And internal stakeholders are going to see these things, and we want to make sure that they reflect the institution's values and mission, etc. Next slide, please. So a few quick pitfalls to avoid here. You want to make sure that you don't set specific targets or head counts for any characteristic or demographic category. That's sort of a no-no. It can, certainly something that can come back to bite us through discrimination claims and lawsuits and investigations, etc. So no quotas of any kind. If you are developing new programs, make sure you're not limiting them to specific groups or demographic characteristic categories. You can target programs, but you can't exclude any individuals from participation in those programs. Again, setting goals that you don't control. We want to make sure we control the outcomes here so that we get it right. You want to make sure you're not unintentionally producing discoverable or materials that may be discovered through Freedom of Information law requests to the state education department. Use your legal counsel here to make sure that plans, particularly the development of those plans, is taking place in a privileged environment. Assume anything you give to SED is going to become public, because it probably will. Either they'll release it or it will be foiled and it will be released in that way. It's not something I would consider, even if they say they're not going to release it, that it would be anything you can rely on. And then internally, you're going to be collecting some sensitive data with limited application. You want to make sure that that's only shared on a need-to-know basis within your institution. Next slide. I think that is it for me. Yeah, thank you.
All right. Well, thank you for that Hall of Fame performance, Seth, and really do appreciate the time that you've taken. As a personal aside, of course, with the inductions, for those of you who are baseball fans this past weekend, I am still pulling as a New York City kid of the 80s, to reveal my vintage, that the two first basemen that I grew up with, Keith Hernandez and Don Mattingly, would one day make it. But that has nothing to do with what we're here for. Let me take you through, though, the OMIG updates on the proposed rule that I want to just make sure that those of you who operate in the healthcare environment are generally aware of. So Kathy, if you would find us to the next slide, I appreciate it. And in the few minutes that we have remaining, let me just tell you about this proposed rulemaking that went forward earlier this month on July 13th. And what it will do if it goes forward in its present form, and comments, by the way, are ones you can submit through September 11th later in this year. Essentially, it would replace, for those of you who track these regulations, 18 NYC RR 521, and it contains 3 subparts. It's important to know that this comes out of the Medicaid redesign 2 activities, and this is after some tail the regulatory structure that's proposed to just ultimately beef up, if you will, Medicaid program integrity reform initiatives. So it would add a 521-1 affecting compliance programs, -2 concerning fraud, waste and abuse and prevention, and then self-disclosure programs as the last. And if Kathy, you go to the next slide, I'll get a little bit deeper. Essentially, if you're looking at 521-1, the idea of who a required provider is that would have to pay heed to these standards would change. And you would be looking instead to see all Medicaid managed care and managed long-term care organizations hailed in, and the thresholds in terms of the substantial portion of business activities change from 500 to 1 million. And all of this is in the Medicaid environment, of course, which is why it has germaneness to the activities of the Office of the Medicaid Inspector General. There are other changes around a provider's compliance program, which I won't list out, but are there for your review. And if Kathy, you'd go to the next slide, please, if you, as a group were to just look under the hood of 521-2 as proposed for revision. Essentially, all managed care organizations hailed in by this, regardless of their enrollment numbers, would be required to develop a fraud, waste, and abuse prevention plan. The difference here is that right now you have to have enrollment exceeding 10,000 for that to apply. So that's a big difference if it goes forward. And also special investigations units would need to be established for those with more than 1,000 or 1,000 or more, I should say, enrollees. So that would be in the vein of staffing on the compliance front, potentially fairly big lifts for the organizations delivering these services in the insured environment. So also within -2 are audit investigation and review requirements and requirements to file plans with the OMIG and onward, which again, you will have in the slides on follow-up, so I won't detail more now. But if Kathy, you'd go to the next slide, please, on 521-3, essentially, again, some changes in definitions would include making it more widely applicable. There is a reiteration of the requirements of the self-disclosure program, all of which is basically to, in a nutshell, take what has been an area of compliance activity that has been governed under standards for some time that are now, if these changes go forward, going to change, and that again will affect the environment overseen by the Office of the Medicaid Inspector General on the plan side. So these are provisions that we're tracking closely. We issued a health law wire on this through our health and long-term care practice earlier this week, if you'd like to read up some more on this. And by way of this update, just wanting to make sure that those of you who are involved in the healthcare and Medicaid environments have an awareness that this is coming down the pike. And as well, of course, the opportunity to submit comments, which we are more than happy to guide you on should that be of interest. And then what I wanted to make sure with our last few moments to do is, as always, give you a chance to pose questions that you may have. As I flip through the chat, it looks like by and large, we have answered them over the course of the webinar. So what I will assume is that if you have questions, you can raise them to any of our speakers or to the bond attorney with whom you are in best and regular contact. I will be back here to host, not this coming week, which will be August 2nd. Adam will be with you, but thereafter on August 9th. And I look forward to welcoming the month of August with you then. Stay cool out there, enjoy the summer as best you can, and we're hopeful as always that this is of help, and we look forward to having you back. In the meanwhile, have a terrific afternoon, and thank you.